closing arguments take place in the Darrell Brooks trial, and like most everything in this trial, it was difficult. Brooks is accused of driving through the Waukesha Christmas parade last year, killing 6 people, injuring dozens more. After the prosecution gave their closing arguments, Brooks said he was not ready to give his closing arguments. He also brought up that he wanted to inform the jury of their rights of nullification. He did give closing arguments, which you just saw moments ago right here on Fox 6, only bringing it up once. It was stricken from the record. Joining us now to talk more about exactly what happened today is attorney Julius Kim from the law group Kim and Lavoie. Thank you so much for being here. We know you were glued to the TV, just like us. He gave the closing arguments, Darrell Brooks, of course. Before we get to any specific questions, what are your takeaways on this today?
Well, it was a powerful day. You know, there was the first half, in all honesty, was just kind of boring because Judge Darrow was reading hundreds of pages of jury instructions. But I thought that Ms. Opper made a good closing argument that, you know, it was as long as it needed to be. It wasn't overly long, but the facts speak for themselves. And then when Mr. Brooks finally got a chance to do his closing argument, he probably argued some things that were inappropriate and that elicited on sympathy and character, et cetera. But I thought it was smart for the state and the judge to kind of let some of that go just so they can get to the finish line of the case at this point in time.
You talk about the little buzzword of the day, the word that we're all Googling and trying to get our hands around, this nullification. Can you break that down in the simplest terms to us who are not as familiar, if you will, with the law in this parameter?
Absolutely. Nullification, just to put it simply, is the notion that you ask a jury to find someone not guilty, even though they might technically be guilty, for reasons that don't have to do with the law. Maybe it's because of sympathy, or maybe because you don't agree with the law, those types of things. So it's legal to argue to a jury that they can do that, or they should do that. At least it's not ethical to do that. But we want jurors to decide cases based upon the law, not based upon sympathy and other intangibles.
I alluded to this earlier. Brooks talked about the fact that there may have been some malfunction with the brakes, if you will, some malfunction with that car that allowed him not to stop. He also kind of talked about himself in the third person, like what if the person driving that car were not to stop? He never really came out and said, I couldn't do it because the car was broke. I couldn't do it because I couldn't do it. What do you make of that, and how do you think that could play with the jury?
I don't think it's going to play at all with the jury, in all honesty, because those facts weren't ultimately admitted into evidence. But that whole dialogue kind of demonstrated how difficult it is for Mr. Brooks to pull off what he's trying to pull off. He's trying to talk about himself in the third person. And in a case like this, where I think intent is really the crucial issue, it's hard to talk about one's intent if you're not talking about it yourself, especially if you're a pro se defendant or a person representing yourself. So I'm not sure he was effective for that reason, because he was still trying to walk this dissociative line of saying, I didn't do it, but if I did, I didn't mean to do it. I didn't intend to kill anyone. And
one of the things he said he was not prepared, as he said, he did not make a statement, but he did say, I wrote this down verbatim, look inside yourself and make the right decision. He repeated that multiple times to the jury, saying they're going to have to live with their decision for the rest of their lives. Is he, at that point, trying to appeal to the fact that he talked about their kids, the fact that he's a father, the fact that he's saying, I did not intentionally do that? Do you think that's the strategy here going in? And if so, again, do you think that will have an effect on the jury?
Yeah, absolutely. I think he's trying to appeal to people's emotions and just, wants people, he's assuming that people may give him the benefit of the doubt and say this was an intentional act, this was a reckless act. But the reality of the situation is that I think that the jurors have already kind of decided which direction this case is going to go. The other fact of the matter is that the jury's not going to have the opportunity to decide whether this was a reckless act or an intentional act, because unfortunately, because of his behavior yesterday, he's precluded from asking for what we call lesser included jury instructions for a lesser charge of first-degree reckless homicide. So the jury's either going to decide that he's guilty of first-degree intentional homicide or not. And my guess is that they're probably going to go and decide in the affirmative.
Pretty black and white, you're saying. Okay. Well, we will wait for that decision. In the meantime, we appreciate your comments today. We're going to get you, of course, on the other end of that decision if you're available. So, Julius Kim, thank you for your insight. We really appreciate it. We'll talk to you soon.